can police officers and rescue vehicles blow through stop signs, red lights, and basically ignore all traffic laws in responding to an emergency, and if they injure somebody, be found not responsible? No. The law covering this one for Rhode Island is chapters 31.12.7, which outlines certain privileges allowed to emergency vehicles when responding to emergencies. And you'll see that the driver of an authorized emergency vehicle may park or stand irrespective of the provisions of any law, proceed past a red or stop signal or stop sign, but only after slowing down as may be necessary for safe operation, exceed the prima facie speed limits so long as he or she does not endanger life or property, prima facie being the posted speed limits on a sign, and 4, disregard regulations governing direction of movement or turning in specified directions. So that's what an emergency vehicle can do when responding to an emergency. They can't just drive around doing this all the time. Now, there are certain conditions, which is contained in General Law 31.12.8, which requires that the exceptions granted in this chapter to an authorized emergency vehicle shall apply only when the driver of the vehicle, while in motion, sounds an audible signal by bell, siren, or exhaust whistle as may be reasonably necessary, and when the vehicle is equipped with at least one lighted lamp displaying a red light visible under normal atmospheric conditions from a distance of 500. That's a big distance. A football field is 200 feet. 500 feet to the front of the vehicle, except that an authorized emergency vehicle operated as a police vehicle need not be equipped with or display a red light visible from in front of the vehicle. So police don't have to have a red light, but other emergency vehicles, rescues, have to have a red light. But even if the emergency vehicle is displaying the light and using the audible signal, they still have to exercise a level of due care. And that's defined in chapter 31.12.9, which says that the provisions of this chapter shall not relieve the driver of an authorized emergency vehicle from the duty to drive with due regard for the safety of all persons, nor shall the provisions protect the driver from the consequences of the driver's reckless disregard for the safety of others. Now, the key word in that last sentence was the word reckless. Normally, for regular people such as myself, ordinary citizens, we are held to a standard of negligence, which amongst the law is seen as the failure to exercise the level of care that a reasonable person would use in the same situation. But obviously, for first responders, police, and rescue drivers, we're giving them certain privileges that we don't give ordinary people. I've never driven a rescue. I'm not a police officer. So there are certain decisions that they will make that myself and other people will not understand, but that we empower them to do. Regardless, though, even if they do it, the standard for police and rescue, as defined by our Supreme Court, is that where the driver of an authorized emergency vehicle, when responding to an emergency call, operates the vehicle in such a manner as to demonstrate a heedless indifference to the consequences of his action, the jury must conclude that they have exhibited a reckless disregard for the safety of others, and therefore the privilege is not extended to protect them. So again, the difference being a heedless indifference to the consequences of their actions. So hope you guys enjoyed the video. So no, police and rescue cannot just simply blast through intersections at 90 miles an hour or city streets and residential areas or really anywhere and just say that, oh, well, I was responding to a call and therefore I'm not liable. No, it doesn't work that way, and for good reason. So hope you enjoyed the video. Please feel free to like, comment, subscribe, share with your friends. And if you have any questions, let me know. Send me a message if you have a case. And until next time, be well and take care.